Please, my lady and my lords, I represent the appellant in this matter, the learned friend Mr. Roth, for the respondents. The logical order of submissions, if agreeable, is to follow the permitted grounds, so taking breach of trust first, then knowledge, then remedy, personal, then proprietary, but subject to a brief overview of the case, which I'll give now. The dispute emanates from £2.5 million deposited on the 3rd of January 2017, pursuant to a trust deed dated 31st of October 2016, appointing the claimant Mary Shovlin as trustee alongside Austin Fergus, her long-standing accountant and business advisor, both personally and to the company. He was one of two brothers operating as Fergus and Fergus accountants, and in alleged breach of trust, Austin Fergus unilaterally, without Mary Shovlin's knowledge, lent some monies to other clients of his, and for the purposes of this case, effectively Mr. Crosby, director and shareholder of the first defendant. It is common ground that the first defendant received £645,000 of trust monies by way of two cheques made out in favour of the first defendant, save that the second was made out to its solicitors. The first for £525,000 on the 5th of January 2017, and the second 2 years later, 14th January 2019, for the sum of £120,000. With the first tranche, the first defendant purchased some industrial land at Mercury Park, Manchester, and with the second tranche, 2 years later, purchased a connected ransom strip. On Mr. Crosby's account, as we will see, those receipts were pursuant to some form of loose joint venture to build out industrial units, and Austin Fergus would participate in that venture. That was forestalled by the death of Austin Fergus on the 6th of February 2019, whereupon Mr. Crosby decided to market the land for sale instead. And one moves then to February 2020, 1 year later. The eponymous Philip Shovlin Sr. had died, and Philip Shovlin Jr. returned to the UK from Australia to assist in family and family company affairs. He met with Henry Fergus, the surviving brother, with his mother on the 7th of February 2020, and learned that money had not been invested in stocks and shares, but had been lent out to other clients. Mr. Shovlin Jr. commenced urgent investigations. Bank records that he was able to obtain showed the destination of the two cheques in issue for this appeal. And the claimant appellant places great store on the content of an initial telephone call between Mr. Shovlin and Mr. Crosby, when Mr. Shovlin first tracked Mr. Crosby down. We'll look at that transcript in due course. That was a telephone call on the 11th of February 2020. It was recorded and has subsequently been transcribed. There was a repayment by the defendants of the capital sum of £645,000 on the 6th of March 2020. And then on the 27th of March 2020, there was a completion of a sale of the land to McDonald's restaurants for £2 million. And finally, on the 14th of March 2023, shortly before the trial, before His Honour Judge Cawson King's Counsel, the defendants made a tender of interest on top of the capital repayment. The appellant contends that the defendants have liability for knowing receipt, and then as to the position of Mr. Crosby personally, his own evidence, as we'll see with tolerable clarity, was that the profits from the McDonald's resale were earmarked to buy a property called Vinesgrove in Knutsford. That acquisition was funded initially by bridging finance, A, to buy it, and B, to repay the capital to the claimant. The appellant's case was and remains that one can trace through these events because the bridging finance was promptly repaid with the McDonald's sale proceeds. Vinesgrove was subsequently sold, but Mr. Crosby retained a portion of land to the side of it upon which a further property called Greenacres was constructed. That property is owned by Mr. Crosby personally. The appellant's case is that he has his own personal liability as a knowing recipient alongside his company, as having received what he knew to be traceable proceeds of monies misapplied in breach of trust. But the appellant brings a proprietary claim against Greenacres. Greenacres represents the monies originally misapplied in breach of trust. The trust monies were exchanged for the ownership of Mercury Way. The same trust monies were then effectively exchanged for the ownership of Vinesgrove and in turn exchanged for the ownership of Greenacres. The appellant's case is that that property is held on trust for the claimant without any offset, whether by reason of a windfall defence or by reference to any alleged expenditure incurred. If the appeal is well founded, there can be, we submit, a disposal of the proprietary claim. As to the personal claims for knowing receipt, where we accept that there could be an offset for expenditure, and there may be other discretionary elements to that remedy, as we'll see, that claim would have to be remitted for accounts and inquiries, as it appears the judge accepted would have to ensue if he'd been persuaded that there was a breach of trust and knowing receipt in the first place. As a further indication of the necessity of a remittal in that respect, footnote 14 of the appellant's skeleton argument gives an indication of some of the problems with the figures. As to breach of trust, the deed is at the beginning of the supplemental bundle. The appellant concedes, and the claimant conceded at trial, that there's nothing in the deed fettering the power of investment. And so by Section 3 of the Trustee Act 2000, the trustees would be at liberty to make any investment which they'd be entitled to make if they were beneficially entitled to the fund. There was in the case no evidence of Mary Shovlin delegating any investment decisions to her co-trustee. And there's nothing in the deed actually permitting expressly one trustee to act unilaterally. But the checks and the bank mandate were certainly a sufficient indication that a single signature was regarded as acceptable and permissible to the bank. And the appellant's factual case that the instruction to the trustees was for an investment in stocks and shares only was not accepted by the judge. That's a factual finding which the appellant does not seek to reopen. There was a section of the judgment at paragraphs 199 to 203 which the appellant did seek to subject to attack in terms of the manner in which the judge treated the evidence and in particular the burden of proof. They were grounds 3, 4 and 5 upon which permission has not been granted. The appellant does not need those grounds in order to make out a case of breach of trust. The case of breach of trust, we submit, is manifest for two conceptually separate reasons. Firstly, ground 1, because there was a fraud on the power of investment, it's evident that the intention of Austin Fergus was to benefit Mr. Crosby and his company, and any potential benefit to the beneficiaries was incidental to that at best. The predominant intention was to benefit Mr. Crosby and the first defendant, but they were not a subject of the power. Alternatively, ground 2, the lending of the money was plainly not in the beneficiary's best interest, and so ground 2 is a conceptually separate allegation of breach of trust. Could I turn, before advancing into grounds 1 and 2, to the transcript upon which the appellant places considerable store? It's in the supplementary bundle at page 79.
That's the 11th of February conversation, is it?
My lord, yes. 11th of February. It's a conversation which jumps around a fair bit. The two men find a lot of common ground. They open up on life struggles. They reminisce. They reflect on life. They reflect on death. It's a lament for Austin Fergus. But within it, there are things that are really only capable of one meaning, which have obvious significance for the claim. Those matters...
Is your argument that the judge was irrational in ignoring the submissions you're about to make, or just trying to put this into some context, legal context? I mean, I know in the sense we're looking at this because you say you place a lot of reliance on it, but what reliance, other than, as it were, merits?
Well, in respect of ground 1, explaining the error of law in that respect, the concept of a fraud on the power of investment was acknowledged by the judge at paragraph 95.5. As part of the introduction to the issue. So there was a nod to the claimant's case, but then...
Well, he's just reciting your submissions there.
Yes, it never got revisited in any identifiable or appreciable way. So if one moves on to paragraph 202, that concept of the defendants having been deliberately benefited by the trustee despite not being an object of the power, it's not the subject of any analysis whatsoever in the judgment. So there's a clear error, we say, in that respect. As to ground 2...
But in a sense, when you make a loan to somebody, you naturally benefit them because you are making a loan to them. I mean, what do you mean? Do you mean that he subordinated the interests of the trust to the interests of the borrower? Or,
yes.
I mean, what do you actually say?
Yes, because if there's an incidental benefit to a person who's not the object of the power, then that may be permissible because the predominant benefit is still for the beneficiaries. But if it's the other way round and the overwhelmingly predominant benefit is for the non-object, then that's impermissible and represents a breach of trust. And the evidence, which we'll see in the transcript, is that Mr. Crosby, having been rejected by mainstream finance, having been referred unsuccessfully by Austin Fergus to a specialist broker, still could not obtain finance. Mr. Crosby appears to be somewhat desperate, and Austin Fergus says, I'll help you out, I'll do it. And so the money was used for Mr. Crosby, upon Mr. Crosby's plea, effectively.
And so is this right? You say that in 202 the judge didn't correctly address that question?
Well, there's no engagement with any of the authority on the question. There's no analysis of the point, having acknowledged that it was a point at 95.5. It's an imperceptible glossing over of the issue.
Yeah,
is that right? I mean, he begins the paragraph by saying that he takes on board various points, and it might be said that these advantageous terms are intended to benefit Mr. Crosby rather than the trust, which does seem to engage with your point that it's benefiting a non-object. And he then goes on to say, however, and then suggests that what Mr. Fergus was doing was lending on the terms that he did, i.e. the advantageous terms, in anticipation of being involved in a project which would be for the benefit of the trust. Now, you might say he's wrong about that, but isn't that analysis engaging with your point and saying, actually, no, he was doing it for the benefit of the trust?
Perhaps to a bare degree, but we say it doesn't meet the legal test. So when we look at Thatcher and the New Zealand case of Wong and Burt in due course, we say it's a misapplication of the principle because the evidence is clear that the overwhelmingly predominant benefit was for the defendants, and we say that's impermissible, and therefore it represents a breach of trust. As to ground 2, incidentally, it's noticeable that my learned friend in his skeleton argument wraps up grounds 1 and 2 together. He doesn't give any particular attention to ground 1, and as to ground 2, there's an attempt to funnel all that through, well, it's an evaluation, it's a factual assessment by the judge, and therefore there's no error of law. We say when one looks at the duty on a trustee to act in the beneficiary's best interest, that's an objective legal standard. And ground 2 is not an appeal against a finding of fact. I mean, it came across the permission threshold as an arguable error of law, and that's the way we seek to argue it.
But just to go back to ground 1, are you saying that the judge applied the wrong legal test? I mean, in the first sentence of 202, he, without spelling it out, he's acknowledging that your argument was an intention to benefit Mr. Crosby rather than the SPH trust. In other words, is that not focusing on the legal test of the predominant purpose for which power is exercised, as you put it? Are you just saying, in fact, he got it wrong on fact, or are you saying
no,
he got it wrong on law as well?
The inescapable requirement we submit is that the judge had to firstly identify where was the predominant benefit. If the predominant benefit is for the beneficiaries and it's an incidental benefit to the non-object, then that may be permissible. If it's the other way round, then that would be the surest indication that the predominant benefit for the non-object is impermissible. That isn't grappled with, not directly, and then having done that, conducted that balance, the judge ought to have applied that against the standard in case law or authority to test whether that conclusion was correct. And having not done that, and paragraph 202 certainly doesn't admit that exercise, we say there's an error and there's a mismatch with the legal standard. The transcript obviously straddles both grounds 1 and 2. The salient parts of the transcript, with a view to being efficient on time, are summarised at paragraph 11 of the appellant skeleton. And at paragraph 11, they do not go in order through the transcript, page 1, page 2, but nor, frankly, does the conversation go in order. It very much jumps around and revisits certain topics. But that's the summary, and clearly there's significance in the fact that the very first words out of Mr. Crosby's mouth were, "You, Mr. Shovlin, probably won't be happy about the way me and Austin had our agreement." That's before Mr. Shovlin had said anything. And then there are the other very compelling indications that Mr. Crosby knew that there was something highly irregular about this transaction. Paragraph 13 of the skeleton is a follow-on from what's summarised at paragraph 11, but that should be read together with a few salient paragraphs from Mr. Crosby's written evidence. So firstly, in the affidavit that he submitted pursuant to the freezing injunction, that begins supplemental bundle page 140. Paragraphs 13 and 14. There, Mr. Crosby had disclosed that he was unsuccessful with High Street Bank then was further unsuccessful, having been referred specifically to a specialist broker. He drew a blank there as well. Paragraph 14. When Austin learned that Mr. Crosby was effectively in the lurch, he offered to lend money. And Mr. Crosby's account was that he was told the money was simply sat there, it was barely earning any interest, and so a figure of 0.4% would be agreeable. Mr. Crosby says his proposal was to revisit that in 12 months' time. In Mr. Crosby's witness statement for trial, which begins on page 178 in the supplemental bundle, paragraphs 26 and 27, page 181.
Sorry, give me that reference again. 181.
Page 181, this is the witness statement for trial, paras 26 and 27. Slightly different emphasis, but effectively the same point, been finessed slightly from the affidavit by the time of trial. I told him how gutted I was, effectively that he didn't have the money and he couldn't get the money. Austin offered to lend me the money to purchase Mercury Way. He told me the worst thing that could happen is I'd get my money back. Those matters, and the matters that are summarised at paragraphs 11 and 13 of the skeleton, should be set against the amended defence upon which the defendants came to trial. Paragraph 8b, which I've cited at paragraph 12 of the skeleton. Coming to trial on the assertion, unamended, defendants had no reason to disbelieve that the monies belonged to Austin Fergus, whether legally and or beneficially. But the appellant says that simply can't be reconciled with the content of the transcribed call. So as to ground one,
well, which particular? I mean, just show us the bit of the transcribed call you say
Yes.
is just can't be reconciled.
the court has it in the supplemental bundle beginning on page 79.
Yeah.
And we can perhaps work through it in order. So page 79, the second GC entry down from the top of the page.
Yep.
Mr. Crosby had started to speak, but it was inaudible. So when Mr. Shovlin is ready, he says, I said, you probably won't be happy about the way me and Austin had our agreement. Over the page.
I mean, there'd obviously been a telephone conversation before this.
There may have been a missed call or a voice message that was being responded to. Nothing of any substance. Page 2, the second GC entry down from the top of the page. I said to him that yard in Trafford Park, he knew the numbers because he'd done the numbers and he knew what the income would have been. I had blue chip planes lined up for every unit.
And
This was an indication of the running of the numbers, we say was consistent with the joint venture to build out the industrial units together. Moving down to alongside the first hole punch.
so why is that inconsistent with the belief that the money was Mr.
Well, that section in isolation it isn't. Well, I'm doing a sort of comprehensive sweep of the content of the call. Alongside the first hole punch, he knew. He brought me back over 25 years about 10 million quid. Then the kids would have had the site in the long run and another crack at it in 25 years of a prime site. Then continuing, Mr. Shovlin says, yep, and Mr. Crosby continues, when I came to sell it, Austin, I just want you to put the money back where it effing came from, because I thought it was his money. Page 3, page 81 of the bundle.
So he's saying he did think it was Mr. Fergus's money.
Well, he is at that point. He is at that point.
Yeah, no, I'm just trying to identify the reason I'm just asking for this, because your assertion is that this transcript is flatly inconsistent.
Yes.
And presumably, therefore, you say the judge acted irrationally, or you'd have to say that the judge acted irrationally when finding to the contrary.
We can certainly draw from this the clear intention between Crosby and Fergus to build out the units together as a joint venture, and that is itself represents a decision by Mr. Fergus to give the money to Mr. Crosby when he knows he can't get it from any other source, in order for Mr. Crosby not to lose out on what's described as a gold mine.
You have to show that the judge's findings were irrational, don't you? As a matter of fact, if that's what you're saying.
Well, I'm not challenging the findings of fact as being irrational or perverse. I'm saying that with the evidence from the call set against the legal test in respect of fraud on a power of investment, there is clarity that there was an intention to benefit a non-object, and that against the legal standard the judge made an error of law in not testing the evidence properly against that standard. And in respect of ground 2, a decision to lend to a man in these circumstances with no security, nothing in writing, the most negligible rate of return, that can't represent acting in the beneficiary's best interest, and so can make out a breach of trust separately.
I'm just focusing on ground 1 at the moment.
Yes.
Which is based upon a finding as to intention, isn't it? Predominant purpose. You say the judge should have found that the predominant purpose was to benefit Crosby rather than serve the interests of the trust.
Well, certainly the judge should have found that, but I think in fact the law would say if a trustee was well intentioned but nevertheless has predominantly benefited a non-object, then that may be impermissible in any event.
I'm trying to nail you down. I'm trying, hopefully, sensibly, just to try and identify whether your ground is a ground of law, a ground of challenge to the judge's factual findings, or a bit of both. I'm just trying to actually make sure I understand what it is, because it does change the test, doesn't it? That an appeal court
Absolutely,
applies.
absolutely. There's a distinct error of law in not testing the evidence against the legal standard for benefiting a non-object. Yeah. Underneath that, perhaps, is a misevaluation of the evidence, a clear failure to give proper weight to relevant matters, and giving too much weight to relevant matters potentially as a subsidiary error, appealable error.
But don't you have to show ultimately that a judge, assuming they got the correct legal test, a judge looking at the material that you started and will finish showing us, could only have come to one conclusion, namely, because unless you can show us that, then doesn't the judge's factual findings stand?
I would agree in respect of the subsidiary question, but the first question,
not a legal question,
simply not applying the test, acknowledging it, but not actually applying it properly. Okay. That's a standalone. Underneath that, yes, it's evaluative, but the weight of the evidence would be such as to intention that if it is factual, that the judge must have reached the wrong conclusion as a matter of evaluation.
Okay.
The transcript inevitably does straddle both grounds 1 and 2, because there are aspects of the transcript which look at what the beneficiaries are getting out of it, where money's being given on an unsecured basis, deliberately not being put in writing at all, the most negligible rate of interest, and effectively just banking on Mr. Crosby's word that this money would be repaid. Even that, which we can draw from the transcript, we say, makes out an error in ground 2. But continuing on the transcript, internal page 3, page 81 of the supplementary bundle, going from the foot of the page, this time, the third GC entry from the foot of the page. As to the lending of the money, Mr. Crosby said, I said to Austin, are you sure? We've spoken about this project. He said, no, George, don't worry. I'm going to speak to somebody and he'll probably help you out. And they will, and we'll sort it. I said the next day, he said that, yeah, he spoke to somebody and it's agreed as long as it's in principle. And George, your word is your word. I said, Austin, you know I'd never let you down. I'd sell the kids before I'd let you down. And so on. That, we say, is only really able to be interpreted as Mr. Crosby realising that it was not Austin Fergus's money personally, that Austin Fergus had to speak to somebody else. Having not got anywhere with the specialist broker to whom Mr. Crosby had referred, this, we say, is Austin Fergus confirming that he had to speak to somebody else about getting the money.
But if Austin Fergus did say that, and if he did speak to somebody else about the money, and if the money which was lent was the trust's money, then who else could he have spoken to other than Mrs. Shovlin? There's a lot of ifs in there, but assuming that this is all true, it doesn't make sense, does it? Unless it was her that he spoke to. Because nobody else could tell him anything about lending the trust's money.
That was not the defendant's case. There was no evidence of that having happened. There was no hint of that in the evidence of that having happened. And it wasn't a conclusion that was pressed on the judge by...
I mean, if we simply focus on what Austin Fergus is said to have said, what other explanation for it could there be?
Well, then Mr. Crosby ought to be asking himself, should I not be seeing some evidence of the consent of the person whose money it is? Do I need to satisfy myself that they're content for it to be in principle and for nothing to be in writing? And so on.
But are you saying that we should be accepting what's said here at its face value and therefore saying at its face value it's inconsistent? Or are you saying that we or the judge should have gone behind this? Is the sort of point.
No, I'm not cherry picking from the content of this transcript. I'm saying that when you look at the totality of the content, there are really the only permissible conclusions are that there was a shared intention for Mr. Crosby to be benefited far more predominantly than anything that could be said to potentially benefit the beneficiaries. And secondly, that to lend money in these circumstances was plainly not in the beneficiary's best interests, and so is a breach of trust anyway. On page 4, I mean, I quite accept that it's easy to pause at each one of these references and test, does that reference in isolation mandate a particular conclusion? Could it be capable of another interpretation? What I'm inviting the court to do ultimately is compile these references and look at them in totality and decide whether it's correct for me to have submitted that there are really only two clear conclusions: deliberate benefit of a non-object and clearly not acting in the beneficiary's best interests.
Are we going to be... I mean, what was said at trial about this?
Well, in the way in which we have the transcripts of large sections of the cross-examination of Mr. Crosby, where in fact these references were put in turn in the way in which I'm reciting them now. And it may be necessary to look at some of the answers that Mr. Crosby gave in due course as part of the piece in terms of testing his knowledge and the way the judge made a conclusion about his knowledge under grounds 6 and 7. but clearly the transcript was examined in close detail during the trial process.
That's why, generally on appeal, unless you can surmount the high burden of showing that the judge was irrational or unsupported by evidence, the appeal court doesn't generally get involved on questions of findings of fact. Of course.
But we haven't gone in this order, but if the law is clear that it's impermissible for a trustee to benefit a non-object, and we'll have a look at the cases that touch upon that proposition. If the law is clear, and if the evidence is clear as to what Mr. Crosby was revealing about his and Austin Fergus's intention, then ground one is good. If the law is clear about a trustee being obligated to act in the beneficiary's best interests and act in the way in which a prudent man of business would act in his own affairs, if the manifest terms of lending to the defendants on distinctly very poor terms and shaky terms, unsecured, unwritten and so on, if the evidence is clear as to that, then that's ground two is good. And
I'm only on ground one at the moment.
Yes. Well, ground one is there's a clear legal standard about predominance of benefit. The evidence is clear, we submit. And therefore the judge's failure to analyse the proposition properly or at all.
Sorry, without wishing to pick you up, I think isn't ground one, it's not predominance of benefit, it's about intention. Predominant intention, isn't it? I thought that's the way you put it.
Yeah, and I qualified that by saying it may be enough that the predominant effect on benefit of a non-object is also able to be representing a breach of trust because the trustee is able to foresee that that's the effect. And so that the proposition of benefiting a non-object may not require predominant intention.
Surely, hang on, doesn't it work this way? You say that the trustee must be using the powers for proper purposes, and that requires you to investigate what was the intention or the purpose for which the trustee was using the power. It's investigating the purpose. It is a sort of inquiry into the subjective intentional purpose for which the power is exercised. It may be that on the facts, if it is blindingly obvious or would have been blindingly obvious that there could be no benefit, for example, to the trust, or that there was a manifestly disproportionate benefit viewed objectively, you would disbelieve the evidence of the trustee as to what his purpose was. But your inquiry still is an inquiry into intention and purpose. It's not just purely an objective test, is it?
We can advance the appeal on improper collateral purpose. All I have in mind is that, and we'll look at this in a moment, in Hillsdown, it's made clear that you can have a breach of trust without maladministration. So you may have a trustee that sort of innocently or blindly stumbles into a transaction which does not have an intention behind it to benefit somebody. But if that is the overwhelming and inescapable effect of what the trustee is committed to, nevertheless, the effect of benefiting a non-object may represent a breach of trust. Okay, that might be an academic debate because we say there clearly is a purpose here. Okay. Just trying to qualify the submission.
Yeah, okay. All right. Well, we'll come to the law in a moment, but okay, I'm just trying to... Fine, okay.
So continuing on the transcript, page 82 of the supplemental bundle. Fourth GC entry down from the top. And he said, right, George, don't worry, I'll do it. And I said to him, are you sure, Austin? Are you sure it's no worry? He said, no, George, listen, I'll sort it. And after a few months, I said, listen, I've got a solicitor here in Salford that's dealing with some stuff for me. Why don't you get a thing signed up? Because you've become poorly. No, George, I trust you. So, deliberate understanding between the two of them that this money was to be lent on an undocumented basis, notwithstanding, it appears, that Mr. Crosby had a measure of discomfort about that initially. Top of page 5. In terms of how Mr. Crosby understood having been successful in getting this money, he volunteered to Mr. Shovlin. The only way I could see that he would do that, that's Mr. Fergus, is if he had his own money put aside to back it up. I.e., Mr. Crosby's revealing, I know I'm getting somebody else's money. I know I haven't spoken to that somebody else. I know I don't know who that third party is. I don't know directly whether they consent. I don't know whether they're agreeable to it being in principle and undocumented, but I will assume and content myself with the fact that Austin must have some money set aside to back it up. At the bottom of page 5, this is indicative of the conversation jumping around. Second GC entry up from the foot of the page. This is after Mr. Crosby had learned that Austin Fergus had had a cancer diagnosis. I said to him, don't tell anybody about that cancer, Austin, not for now. As we'll see in the cross-examination of Mr. Crosby was rather reticent about revealing why that was important for the cancer diagnosis not to be revealed. One can then move to page 15, internal page 15, page 93. In fact, we should pick it up at the bottom of page 14. Final entry at the bottom of 14. And he said, George, as long as you can honour this, we're getting about 0.4%. Needs to be better on what we're getting. That's the agreement. I'm not messing about with money for nothing. I can't do it. It's got to be something. Even if it's 1%, it doesn't matter. Then Austin got poorly, and I said to him one day, I feel shit about this, Austin. He said, George, and I actually said to him, a year's gone by. Does some interest need to be paid? He said, George, don't worry, just as long as that money gets back to where it needs to get back to, i.e., not Mr. Fergus's own money at all. Then there's a reference to just bettering the negligible interest, and that would be sufficient. Gentleman's agreement reference. But then in the middle of the page, Mr. Crosby says, I never found out. I thought, how's that worked out? Did it belong to a fund? And why wouldn't everyone not want everything right? But he trusted me, though. And I hope he's not dealt with everyone like that. Mr. Shovlin asks, so was the agreement there's a share on the uplift? And Mr. Crosby says, no. There was no agreement with me and Austin. All the agreement was that the money had to go back to where it came from. We should have been turning that round in about 12 months, only for the fact that Regatta came in. That's the issue with the ransom strip. Paused us with a court case, so the agreement was make sure there's more than 0.4%. We need an annual return. But the thing went from bad to worse with him getting cancer. The objectives had to change. To be fair, I think he was, even if that money wasn't his, he was possibly even borrowing the 1.2 million. That was the fund to build out the unit. And then page 18. Mr. Shovlin has, I've skipped over this bit, but Mr. Shovlin has started to talk about an awareness that other clients of Fergus had received some money. Just alongside the first hole punch, Mr. Crosby says, I'm sorry about the way I've put it across. But listen, they failed in a big way because it sounds too big, there's too much money. I never realised it was anything like that big. When you said 7 figures, I thought it was big, but I know I was secure. I'd never let him down. Henry never did nothing about anything. Keep it close to your chest, George. No one needs to know about what we do. Austin wasn't dead 2 days, and I had to go in and explain to him, that's Henry, because I realised that Austin wasn't supposed to die. He's left a mess. I went in and told him straight, listen, Henry, Austin's given me the money towards this site. Move to the next book, 1GC. I thought it was I realised, I did my own due diligence, and I realised what SPH was in the end. Mr. Shovlin hadn't mentioned SPH at all.
So what
in this
so
correspondence?
what was the comment in the middle? And that's how much it is, and that's when he's given it me. I said, don't worry about any of that. Passed away with me because your money will be back to you. Who's the you?
Got to be Henry, I imagine. Not entirely clear. Well, it's a continuation of, listen, Henry, Austin's given me this money. That's how much it is. And when he's given it to me, that's Austin. I said, don't worry about any of that. And then a reference must be to Austin having passed away. Your money will be back to you.
And Henry, in his capacity, what capacity?
Well, just the surviving brother and the partner of the accountancy firm who would be picking up the pieces of these affairs.
So it could be, it's not the money will be going back to somebody else.
Well, probably it is in fact, because that's where Mr. Crosby volunteers in the next breath. I did my own due diligence and I realised what SPH was in the end. So he seems to have tracked down himself where the money had emanated from. Mr. Shovlin hasn't, in the course of this call, even mentioned SPH. So
yeah, but he realised what SPH was in the end.
Yes, in the end, yes. And that of course, he's come to trial absolutely maintaining he knew absolutely nothing about a breach of trust. So that's not the point. It's clear from the call that he knew it was somebody else's money. He just didn't know who the identity was at the beginning.
Well, it's also not that clear when he realised it was someone else's money.
Possibly. Although the references that we've been through,
Yes, I know what your case is.
it's hard to drag those back in time when you look at the flow of the conversation. What is clear is that Mr. Crosby's making a plea because he feels bitterly disappointed that this opportunity would slip through his fingers. And it clearly would slip through his fingers. The RBS won't lend to him. The broker can't do anything for him. Mr. Fergus is the last port of call, it appears, and he persuades Austin Fergus to lend the money. And so him being benefited by Austin Fergus being prepared to part with the money, we say is clear. As to the knowledge about it having been somebody else's money, contrary to the pleaded defence, paragraph 8b, never had any reason to suspect it wasn't Mr. Fergus's money. The defence is unsustainable, because even if the knowledge came later, then that plea in the defence needed to be qualified.
Quite. We're not, I mean, that's a slight side issue for the purposes of grounds 1 and 2 of the appeal.
Yes. Yeah, I'm deferring to the question, which is a proper question, but when does the conversation suggest that Mr. Crosby knew it wasn't, in fact, Austin Fergus's money? We say that there is sufficient clarity in the conversation that he knew at the very beginning. Because this is probably the final reference. Yes, it can be the final reference. The bottom of page 18. Mr. Crosby is ruminating upon, well, who would the person be whose money it really was, and would it be somebody like the likes of Dermot McKenna? Because Mr. Crosby was a bit perturbed if it would be somebody like that, because at the foot of the page, he's concerned that it might be somebody that would try to pull the rug out from underneath his feet once he's done all the hard work. And Austin said, no, George, they're not people like that. These are honest people. And in the end, we did speak about your family. He appears to be drawing a distinction between having some comfort at the beginning that the people whose money this was were not like Dermot McKenna, and then in the end, I concede in the end, the apparent identification of it being the Shovlin family. So, coming to the law on grounds 1 and grounds 2, with the benefit of that review of what was exchanged between the two men in the first call, as I say, it's conspicuous in Maloney Friend's skeleton argument that grounds 1 and 2 are dealt with together. He funnels it all into, I'm simply trying to challenge findings of fact. In the authorities, the seminal case is Thatcher, which is in bundle 1 of the authorities beginning at page 7, where the principle is identified but held not to have been breached. But the principle is then carried forward into the later authorities. It effectively appears to be the font of the principle. And we see that explained on page 13. And this marked passage with the red line is actually, I hope, an answer to the observation of my Lord Snowden in respect of intention or effect.
Yeah.
This is not a common law fraud. It merely means that the power has been exercised for a purpose or with an intention beyond the scope of or not justified by the instrument creating the power.
But the point I was making to you is that it's essentially a subjective test. But if I put it into the corporate context,
yes,
it's a director of a company using up the power under the articles for an improper purpose, which is very clearly, I think, a subjective question. But there comes a point in time at which a director who asserts that his purpose was one that is so bizarre that nobody could possibly believe that was in truth what he intended. So that as a matter of evidence, the court would say it's a subjective question, but objectively that is just so bizarre an assertion that that's what your purpose was. We just don't accept you had it. But it's not an objective test, is the only point I was making.
and certainly that's how it's analysed in Hillsdown. When the pension scheme is moved, what's behind the decision to move it?
Yeah.
And the holding was it's an improper collateral purpose. But of course the judge here didn't even ask the question of the intention, and so the error appears at that point.
Yeah. But anyway, but this at least on its face, at least the starting point suggests that it's a subjective inquiry into the purpose or intention of the party, of the trustee.
Yes. We can move to Hillsdown. The New Zealand authority is there for completeness. Nothing. We don't learn anything else from the New Zealand authority. It's an example where the principle is identified and then held to be breached. But probably the more helpful decision is in Hillsdown. In very brief outline, it's the transfer of a pension fund to a different scheme. The change of the scheme was done in order to permit a release of a surplus back to the employer. The Ombudsman found that represented a breach of trust because the purpose of the switch was for the benefit of the employer. The High Court appeal from the Ombudsman's decision was dismissed. the court agreeing that there had been an improper collateral purpose. On page 55 of the authorities bundle, page 880 and 881. 881 has been marked. 880 probably should have been as well. B through to F. What the Ombudsman concluded in terms of what the provocation of the change of scheme was. 881, the conclusions as to the essential features of the bargain. Endorsement of what had been said in opening the appeal. Purpose of the transactions was to ensure that there could be a return of surplus to Hillsdown in circumstances where the deed did not on its terms permit it. The passage that I had in mind about you can have a breach of trust without maladministration, that's actually on 884 between C and F. This was Mr. Austin Fergus consciously deciding to lend money for a collateral and unauthorised purpose. Mr. Crosby's affidavit, paragraphs 13 to 14, is effectively already revealing that in itself, but those two paragraphs, fortified by the transcript references, show that the two men decided that the opportunity was regarded as too good to miss, and that Austin Fergus had to do what was necessary in order to see it not slip through Mr. Crosby's fingers. That, we say on the law, is a clear and identifiable breach of trust, and the judge erred by effectively glossing over this aspect insofar as it was given the barest attention. It was not done properly by asking the question about intention or effect of the transaction in the first place, and certainly not testing it against the proposition in Vatcher and Paul. As to ground two, if ground one fails, separately we say that the breach of duty by a failure...
Is this right, that the judge in 202 dealt with it in terms of consent? The judge dealt with it in two ways. He said, first of all, I'm not sure that that it's an improper purpose, because I can't be sure as to the terms on which the trust was established. Is that right? And then he also raised the question of informed consent. And how do you say that those two justifications fit or don't fit the test you just described?
Well, firstly, we say there's inexcusably missing from the analysis. What does the law require about benefiting a non-object? What do I find was the intention of Austin Fergus insofar as I can discern it? And whether I can or can't discern the intention from the material available, what's the effect of the transaction in terms of balance of benefit vis-a-vis non-object and beneficiaries?
But is your point that, for example, it would have been equally a breach of Mrs. Shovlin's duties as a trustee to have consented to this transaction? I mean, that must follow, mustn't it? If Mrs. Shovlin was consulted on ground one, she was as much in breach of her duty in consenting to this as Mr. Fergus was.
Yes, but that was just never a feature of the proceedings from first to last. She forgive me.
But isn't it relevant to your appeal? Because the judge is referring to, I can't conclude that her informed consent wasn't achieved. And the question you're being asked is, well, even if it was, what difference does that make? If the trustees together exercise a power with an improper purpose, isn't that still a breach of trust? Unless the trustees comprise all the beneficiaries.
Yes, or the beneficiaries themselves consent, and the claims not being brought by the beneficiaries could still complain on the law under ground one if there has been a predominant intention to benefit a non-object.
So who is the claimant is Mrs. Shovlin?
But acting as trustee.
Acting
Yes.
as trustee.
Yes, as the sole surviving trustee.
In circumstances where
There was no evidence that she knew anything about it.
well, there's no evidence from her full stop.
Indeed, but it's not part of the defendant's defence that she did know about it or consent, and there are no findings by the judge that she did. The appeal
There are findings that go quite a long way in that direction, because she was described as a switched-on lady who got sent the bank statements and had regular meetings with Austin Fergus.
Yeah, I agree.
And then the judge talks about can't find that there wasn't informed consent.
Yes, and that's why the appeal is slightly hampered by the non-permission on grounds 3, 4 and 5, because of course the appellant was challenging the manner in which, here we see it in paragraph 2, the judge appears to have reached a sort of default conclusion, unless I can be confidently dragged away from the conclusion that this wasn't okay. I'll assume it was okay. But I accept we have not received permission on grounds 3, 4 and 5, which was part of the challenge to para 199 to 203 of the judgment. But there's no, if the surviving trustee is complaining about the effect of the transaction being that the beneficiaries were clearly not benefited and somebody else who was a non-object was, unless there is a finding that she knew and consented, and then probably in turn that the beneficiaries knew and consented, we say that ground 1 still runs.
Well, don't you have to read 202, which you focused on, together with, for example, 201 little 5, where the judge says that this might well have been the sort of investment, if made with monies belonging to the trust, that could have provided for a good return on a fairly safe and secure basis, better than the accountants in Warrington were doing. And then he also talks about participating on behalf of the trust in a joint venture. And doesn't that suggest that, if his findings are right, that this was done with the intention to benefit the trust? Because there was little downside. I take the point about it being unsecured, but subject to that, there was little downside, and there was better return than the accountants in Warrington were achieving, and the possibility of significant upside. And that all sounds like a deal which the trustees would have been entitled to enter into, or at least that it would have been an intention they could have had consistent with the purposes of the trust.
Not just unsecured, deliberately unwritten. So deliberately resting only.
Well, that's all very odd. It's all very odd.
Only resting
I don't need to be persuaded about that.
So there's no, well, but my lord says there's no downside. The downside is Mr. Crosby doesn't keep his word. It's only on his word.
Sorry, we're just trying to distinguish, put aside for a moment the question of the terms on which the lending was done, which, as my lord has said, is very odd, and maybe a separate ground for complaint. I'm still focusing on ground one.
Yes.
Because you're saying that this was done as a breach of trust and should have been found to be a breach of trust because of the subjective intention of Mr. Fergus to benefit Mr. Crosby and his company rather than benefit the trust of which he was trustee.
Yeah.
So it's all about subjective purpose and intention, fraud on a power. Nothing to do with terms at the moment.
Yes. No, my lord, yes.
And so my lord's putting to you that 201 sub 5, if found, would be an answer to a fraud on a power argument, wouldn't it? I.e., if it was thought that this could be a benefit for the trust, it's something that could be done within the scope of the powers. Now, it may have been done on terms that were independently a breach of trust, but the purpose, if subjectively held, would have been appropriate, wouldn't it?
Well, we say the purpose is clear from Mr. Crosby's own evidence. I'm getting this money because it's the only now last available source of the money, because Mr. Fergus realises I can't be funded through any other mechanism. So that's clearly the purpose. We have that from his own evidence, then it's fortified by the transcript. The claimant, Mary Shovlin, says, I'm complaining about this as the sole surviving trustee. I'm alleging a breach of trust by my fellow trustee. I'm saying I knew nothing about it. I'm saying it wasn't discussed with me. And
did she say that?
Well, through the claim. The judge is critical.
No evidence.
No, the judge is critical of her not being called. Mr. Shovlin said she's extremely ill. He didn't want to put her through the ordeal. He gave a very candid explanation. The judge decided it wasn't satisfactory. She did not give evidence. But there's a statement of truth on the particulars of claim and on the amended particulars of claim. And so her case was...
She didn't submit herself to cross-examination.
Yes, yes.
So the judge is entitled to weigh that as he didn't draw an adverse inference.
Well, he did, but he did not conclude. He did not reject the claim on those factual elements, saying, I'm making a finding that she did know and she did consent. Then they're not features of the judgment. So unless there is a finding that she knew and consented, then she is in a position to complain about the breach of trust. And certainly there's no evidence from anywhere that the beneficiaries of the trust knew anything about it. So we don't accept that ground one is closed off by that feature, the fact that she did not give evidence. She was in a position to bring the complaint. The defendants came to trial saying we had no reason to suspect it was anybody else's money, no reason to suspect it wasn't Austin Fergus's money. The affidavit paragraphs together with the transcript, we say, make that completely unsustainable.
Put aside for a minute what Mr. Crosby, you say, believed or didn't believe. I'm just looking at the question, the way you put ground one. Ground one is focused on the subjective intent of the fiduciary or fiduciaries. And you say that the judge could only rationally have concluded that this was done for an improper purpose, fraud on a power, by Mr. Fergus, by Austin Fergus. And if consulted Mrs. Shovlin, or if not consulted Mrs. Shovlin?
He doesn't seek to make any findings about whether he thought that she was likely to have been consulted or not. It was
But what I'm trying to tease out is your appeal has to be on the basis that a judge hearing this case, with the evidence such as it was in front of him, could only have reached a conclusion that this transaction was a fraud on a power. That has to be your case.
Yes, and it is. The judge could only have concluded that this was a deliberate lending of the money for the purposes of Mr. Crosby not losing out on the opportunity, where his own evidence was, I had no other means of getting funding, so but for Mr. Fergus's indulgence, I was stuck, the opportunity would have gone, the gold mine goes, but Austin Fergus decided he was prepared to rescue me. That already makes any arguments about, well, could the beneficiaries have got something out of it if the gamble had paid off, if Mr. Crosby had been good for his word? Any question about, or any arguments about the beneficiaries' interest, if things all lined up properly and proceeded, they were clearly relegated far behind the benefit to Mr. Crosby. And the overwhelming thrust of the evidence is to that effect. But then, further, when you move to what Mr. Crosby was volunteering in the transcript, it is clear that he knew this was slightly odd, a deliberate, keep it in principle, close to your chest. No, you don't need to put it in writing. Don't worry, don't trouble the solicitors in Salford. This is somebody choosing to pin their ears back and hope for the best, that it all works out. The money comes back either because you can repay in a year or because we build out together.
But if it's an obvious abuse of power, so obvious that the judge ought to have found it by Austin Fergus, and Mrs. Shovlin was not consulted, what weight was the judge entitled to give to the fact that she was supplied with all the bank statements? There was no attempt to conceal what had been done from her.
That's got some forensic value, it's got some evidential value, but it doesn't intrude materially on ground one, Vatcher and Paul. Has there been a benefit of a non-object or not?
Isn't it odd that if this was done without her being involved in the decision for an obviously improper purpose or intention, it is odd, and isn't the judge entitled to draw some inference from the fact that she was given the wherewithal to understand that this is what had been done?
She comes to court to complain and say, I didn't consent to this, and you've made no finding contrary to that, rejecting my case entirely, saying that I did consent. Therefore, I, as the surviving trustee, am saying we're dealing with a transaction conducted unilaterally by my co-trustee. I'm entitled to complain that that's benefit of a non-object.
Well, she has to demonstrate, doesn't she, that the subjective intention of Austin Fergus was not to do something which might have benefited the trust, but to prefer the interests of Mr. Crosby.
And she was fortuitous in being able to demonstrate that by, firstly, the evidence that Mr. Crosby volunteered in his affidavit pursuant to the freezing convention.
Can I just understand this point a bit more, if I may? You're, as I understand it, you're saying sort of look at the facts. This is obviously a really significant benefit to Mr. Crosby. He can't get the money from anywhere else. But just postulate for a moment that for whatever good or bad reason, the trust funds were otherwise sitting in a bank account and were going to carry on sitting in a bank account, earning no more than 0.4% or whatever it was. There was no intention to do anything else with them. a decision to lend out slightly more, put to one side the lack of writing, the lack of security. Think to yourself, Mr. Fergus has known Mr. Crosby for a long time, he's sure he's good for the money and so on. What's the difference there between a poor investment decision or a careless decision? You should have documented it, you should have sought a better rate of interest. And your purpose is, or predominant purpose is to benefit Mr. Crosby. Because if this had been a secured loan at 2% over base, it would still have brought those benefits to Mr. Crosby. It wouldn't have given materially additional benefit to the trust. What I'm trying to say is I think you're using the balance of actual benefit to say you must infer from that the purpose was, or predominant purpose was to benefit Mr. Crosby. I'm not sure that's the right way of looking at it.
But the whole run-up is Austin Fergus has made a decision to raid the fund in circumstances where he knows that Mr. Crosby wants to achieve something in terms of a purchase but simply cannot do it. Austin Fergus had firstly, in fact it may even be slightly different if Mr. Crosby had said, look, I've been round the houses with brokers and I can't get anywhere, but we know from what Mr. Crosby volunteered, Austin Fergus's first decision was to put Mr. Crosby in touch with a specialist broker. The broker will hopefully, fingers crossed, be able to help. The broker can't help. Mr. Crosby becomes Mr. Fergus's problem again. And Mr. Fergus says, I'll use somebody else's money to see that you get what you want, either because you want it or because I don't want to see you lose the opportunity because I can see how much it means to you. It's the clearest case of benefiting a non-object. The comparison with what if there were slightly different terms, how would that affect the balance of interests? That's firstly a different case. It doesn't have the same initial, you've got to focus on the initial provocation, which is...
Okay, you rely very much on the history of trying to find sources of finance elsewhere. And therefore this is a problem and Mr. Fergus is trying to help solve that problem. That's the way you put it.
Yes, the advantage that the appellant has is that is Mr. Crosby's own evidence in the affidavit. Yes, RBS no, broker no. Then he says, I didn't ask Austin Fergus to lend me the money. But when he heard that the applications had all been refused, he offered to lend it. Starting from there, then moving into the transcript of the conversation with Mr. Shovlin, Mr. Crosby knew it was somebody else's money. He was perturbed about all of this being effectively secret, no security, not even documented, etc., etc. We say it's the clearest case that one would ever see of a decision by a trustee to benefit a non-object. The issue about Mary Shovlin's ability to complain about it on her case that she knew nothing of it, that's a side issue, but there's no finding that she did, there's no finding that she consented, and there's certainly no finding that any of the beneficiaries consented or knew anything about it. So we say the judge ought to have found a breach of trust by Austin Fergus.
Right, well that's a very clear summary of your case. We better let you move on, I think, because we've got quite a ground to cover.
Indeed. Round two. My learned friend tries to funnel all this into factual findings and to suggest that the appellant's trying to interfere with factual findings. We say that's not the case. There is an objective legal standard about the duty of a trustee to act in the beneficiary's best interests. That standard is the prudent mannered business dealing with his own affairs. This court can revisit the judge's conclusion on an undisturbed factual backdrop. Henderson and Foxworth, which is the decision that my learned friend relies upon, that was a sale at undervalue case. Everything turned upon the the credibility of the witness, was the evidence accepted on the core questions. The conclusion was that there was a pre-existing loan given as part of the consideration. So what appeared to be an apparent sale at undervalue actually wasn't a sale at undervalue. The appeal in Henderson and Foxworth was saying, well, insufficient reasons have been given for that conclusion, therefore the question's at large again. But that was truly a factual findings case. Was the witness believed or not? Here, ground 2 is different. And we say that the following constituent elements show that this was a decision out with the best interest of the beneficiaries. I've covered some of this ground already. An undocumented loan, deliberately undocumented, keep it close to your chest. If the gamble paid off, then there would be a hope that Mr. Crosby kept his word, but that wouldn't be enforceable. We know that the market did not regard Mr. Crosby as a good risk, which is why the market wasn't prepared to touch him. So in comparison with more or less anything else which could have been validly done with this money, the beneficiaries would have been far better off by any other transaction, taking out a bond, putting it on a proper deposit account. Mr. Crosby's affidavit evidence, paragraph 4, is that if the money had been repaid after a year, and let's just focus on the first tranche of $525,000, on the interest rate that he says was all that Mr. Fergus was interested in, the $525,000 would have earned £2,100 in 12 months. The trustee, acting in the best interest of the beneficiaries, by reference to the standard of a prudent businessman, would not have lent money on those terms at all. If it was in the best interest to lend out money, then there were any number of mechanisms by which the return could have been secure, but not just secure, but appreciably far better. The respondents can't drag this into reasonable care and skill territory. This is a deliberate choice not to document the transaction. It was a form of joint venture. See Mr. Crosby's affidavit, paragraph 23. That therefore represents an element of self-dealing by Austin Fergus, which is
Sorry,
a breach
did you
of...
say affidavit?
Sorry, Mr. Crosby's affidavit 23 says that the follow-on part of the agreement was that they were going to build the site out together. Mr. Fergus would provide further money.
Sorry, give me the reference.
Sorry, page 142 of the supplemental bundle.
And there's no, I mean, the judge, when he refers to that, suggests that this may have been on behalf of the trust. So you're pushing the point now as self-dealing by Mr. Fergus.
The foundation for that is paragraph 23.
Yeah.
We would respectfully suggest page 142 of the supplemental bundle.
Sorry, so 23 says, I discussed this with Austin. He said he would provide the finance and we would build the site out.
Yes. So there was a part 2 of the agreement, which is that Austin would be able to find a further 1.2 million. Last line of paragraph 22. And then with that money, they would build the units, and then they'd enjoy the 10 million plus the 25 years of further rental income for the children. So I appreciate we've covered a lot of ground, but in the transcript we did see the reference to the 1.2 million. But obviously the cancer diagnosis scuppered that, and Mr. Crosby said he wasn't.
But are you saying that
any further.
When you say that's self-dealing, are you saying that this was money that would have been provided by Austin Fergus personally?
That was entirely unclear where the 1.2 million would come from. But Austin Fergus, having used the trust monies in order to make the acquisition, then clearly had part 2 of an agreement with Mr. Crosby that further monies would be provided pursuant to the joint venture to build out.
But on behalf of the trust? What's wrong if it's on behalf of the trust? What's wrong with that?
Well, it's still wrong if the beneficiaries haven't consented to it.
Why?
Well, Mary Shovlin's cases, I knew nothing about this. I didn't know part
Yeah, that's
one
a
or
different
part.
point.
Yeah,
Sorry.
didn't know part one or part two of the agreement.
Sorry,
If
you're going to have to, go more slowly for me.
yes,
Because you've suddenly sort of thrown into the mix things like self-dealing. And I'm just trying to fit what you're actually saying is wrong with this. I mean, I understand an argument that no careful trustee could have, assuming for this purpose you fail on ground one, and I see that the two are perhaps related in the sense that a trustee who doesn't extract the best terms from somebody who can't get money elsewhere might be said to be intending to favour the borrower. I mean, I do see the linkage.
yes,
But assume for present purposes we're looking at ground two separately. So you fail on ground one. So this is a transaction which a trustee could properly have done within the investment powers under the trust for proper purposes. It's possible to criticise the trustee for having done so carelessly by failing to get security, document and obtain an appropriate rate of interest. But that wouldn't help you, would it, if it's done carelessly?
no,
So you have to say that it's done in breach of the duty of loyalty that the trustee owes.
yes.
So what do you say was disloyal about the terms on which the loan was made?
Well, if one just has in mind how it was put by Lord Justice Millett in Bristol and West, the distinguishing obligations of a fiduciary is the obligation of loyalty, which has several facets: good faith, avoiding a conflict, not to profit from one's position as a fiduciary, not to act for one's own benefit or for the benefit of a third party. So the non-object it's actually part of the fiduciary duty on the trustee too. So grounds 1 and 2 are stitched together. Not to act without the informed consent of the persons to whom the duty is owed. They're the key facets of the obligation of loyalty of a fiduciary. This is not Mr.
Well,
Fergus.
you only need to get the beneficiary's consent if you're in a position of conflict or you would otherwise be in breach of duty. You don't always have
Well,
to
or if you're acting arguably for your own benefit or for the benefit of a third party.
That's a position of conflict.
Yes.
So you have to identify. I mean, how do you get into this? Are you saying was your case in front of the judge? Is your case that the judge should have found that this was a position of conflict? In which case, don't you have to say that stage 2 would have been done for Austin Fergus's personal benefit? Is that what you are saying?
The joint venture at paragraph 23 of the affidavit is really an add-on. We're already saying that there's a breach of trust by reference to the standard of the trustee's obligation to act as you would as a prudent man of business in your own affairs, by simply the terms.
But that's not a breach of fiduciary duty.
No. That's why this is an add-on. Let me just, if I box off the ordinary aspect of breach of trust by not acting in the beneficiary's best interest, and it's not just loyally doing your incompetent best or acting carelessly. The terms of the transaction, no security, negligible rate of return at all, insignificant rate of return, deliberately not documented, lending to somebody who's a poor risk and the market won't touch. That's going outside. That's a trustee not acting reasonably for the legitimate purposes of the trust, and that's still a breach of trust. But further, there is disloyalty in having, and again, it's all on the defendant's own evidence, having agreed to do this, not just to deliberately benefit Mr. Crosby, but further, to join in with that benefit, potentially on a personal basis. That's certainly what paragraph 23 would be describing at face value, that further money would be obtained, source unknown. We would build the site out.
Okay, but we haven't got the judge making any findings of fact about possible potential personal involvement by Mr. Crosby, the judge does refer to the possibility of a joint venture on behalf of the trust, but I don't think you've got factual findings underpinning what you're relying on paragraph 23 for, have you?
I think that's a fair observation. And I accept ground two as expressed in the ground is focused on the objectively extremely poor terms of the transaction as Mr. Crosby introduced it.
So you say they're so poor they go beyond carelessness
Yes. Yes.
and are a breach of trust.
Yes.
Although you accept there is quite a link to ground one because it's quite hard to disentangle that from your argument about a purpose of benefiting Mr. Crosby.
Well, they complement each other, one could say that, but I don't think they're inextricably linked, so that ground one doesn't get home unless ground two also does or partly does. Mm-hmm. Because let's just assume Mr. Crosby comes with a proposition. Forget about Mr. Fergus's intention to benefit Mr. Crosby. Mr. Crosby just comes and says, look, you're a trustee. Would you consider lending some trust money? I'd like $645,000. I'm not really going to give you any interest. I will aim to repay you in a year, but I can in no way guarantee it. I should let you know that the market regard me as a very poor risk and will not lend to me from any other source, mainstream, subprime, whatever. I can't and won't give you any security. I've got nothing to offer, or nothing that I'm prepared to offer. I understand that the terms would be that none of this is putting in writing either. If that proposition is put to a trustee has to say that is plainly not in the best interest of the trustees by any objective standard.
Is it an objective standard, or is it that a trustee has to act in what he genuinely believes to be the best interests of the trust, of the trust or the beneficiaries? Because that's the corporate standard.
Well, in the Olswang decision, Mr. Justice Neuberger suggested that it was an objective test. The Court of Appeal remitted the case back. The issue wasn't applicable to the main case as pleaded, and so it was remitted to go back to trial. But there was no disagreement. It remains probably an open question, therefore, as to whether that postulation of the test as an objective one is correct. But certainly...
Sorry, just to follow on from my lady's questions for you. I understand the proposition that a trustee must act for proper purposes. In other words, what they subjectively believe are the purposes for which the powers were conferred upon them. If you win on that, then you establish ground one. But if you fail on ground one, such that we must assume by the time we get to ground two that Mr. Fergus was acting in what for a purpose which was legitimate, which he believed to be legitimate, an investment for the trust. It's possible that these facts support a conclusion that he then did so very negligently, i.e. in breach of the duty to act as you would as a prudent man of business. But I use the word negligence just to be clear that it's a duty of care, an equitable duty of care, which in fact doesn't then help you on your further remedies. In other words, a breach of the duty of care doesn't, because it's not a breach of fiduciary duty, it doesn't give rise to the other remedies. What I think you say, if I've got it right, is that because this was, on the face of it, such a grotesque failure to attend to the obvious matters that are professional man would attend to, namely getting security, getting an interest rate and documenting it, that you can in fact infer that it was not being done for proper purposes.
Yes.
Which is why ground 2 is in fact stapled to ground 1 in that way.
Yes, if one looks at...
But then you've got, effectively, you are saying that it's a breach of trust, a breach of fiduciary duty, which is a question of fact. And you do then have to come back to saying that any reasonable judge would have found, given these terms, that it wasn't just negligence or oversight, but that it was a misuse of the power to benefit somebody else.
Well, we don't just go back to ground 1, but you're just on the objective assessment of the terms of the transaction. You are not acting properly for the legitimate purposes of the trust, and that is still a breach of trust, regardless about whether you've intended to benefit Mr. Crosby. They don't completely overlap. If one looks at Leroyd against Whiteley in the authorities bundle, beginning at page 84, volume 1. House of Lords 1887, an old case, but current in the textbooks for proposition. Page 88, in the very middle of the page, there are some limits beyond which it's manifest no trustee is authorised in going.
Sorry, page 88 of the bundle.
88 of the bundle, right in the middle of the page between the hole punches. Trustee must use ordinary care and caution, although it's impossible to lay down an absolute rule. There are some limits beyond which it's manifest no trustee is authorised in going, and that then is explained in the marked passage on page 90. As a general rule, the law requires of a trustee no higher degree of diligence in the execution of his office than a man of ordinary prudence would exercise in the management of his own private affairs. Yet, he's not allowed the same discretion in investing the monies of the trust.
This is a case about breach of the duty of care, isn't it?
Well, as we understand it, it's where's the dividing line? What crosses into a breach of trust? And this passage on 90 seeks to explain that. Businessmen of ordinary prudence may and frequently do select investments which are more or less of a speculative character, but it's the duty of a trustee to confine himself to the class of investments which are permitted by the trust, and likewise to avoid all investments of that class which are attended with hazard. So long as he acts in honest observation of these limitations, the general rule will apply. So,
yeah, but isn't that just saying a trustee has to first of all act within his powers, i.e. he can only invest in a class of investments which are permitted by the terms of the trust? That's a question of acting within powers.
I agree.
Which a man in his own affairs is not subjected to, because you can do whatever you like with your own property if it's yours. So that's a purpose point. And then likewise to avoid all investments of that class which are attended with hazard. That's just saying you must, as it were, you must select the investments within the power carefully. I mean, I thought Leroyd and Whiteley's all about purposes and duties of care. It's not breach of fiduciary duty in the sense that gives rise to the other remedies that our current case is all about, is it? I mean, there's no attempt to make a third party liable or trace here, is there? This is suing. Isn't this suing trustees for wrongful investments?
The ultimate conclusion was that because they hadn't acted with ordinary prudence, so they breached the standard that's being described on 90, that therefore there was an obligation to make good the money.
Yeah. Right, but this wouldn't allow you, for example, to pursue remedies against a third party on the basis that they were involved in a breach of fiduciary duty, a knowing recipient or a dishonest assister, would it? I mean, this is a breach of the duty of care.
This seems to be support for, you just don't have a binary choice between breach of reasonable skill and care or disloyalty. You may have a breach of trust in between, an actionable breach of trust, which is where the trustee has gone beyond the limit, beyond the line of, well, I thought it might have been permissible, and if it was my money, I would have regarded it as an acceptable risk. Because if one carries that through to page 98, which is the Mr. Justice Neuberger decision in Olswan, which cites Leroyd and Whiteley, and then that's under the subheading of the test for a breach of trust. And so getting over the line of, well, this is just carelessness, it's not, and carelessness is not a breach of trust. A breach of trust can exist in the fact that the investments which are permissible for a trustee are more circumscribed than the trustee could do on his own account. And then we see that at the bottom of 99 going into the top of 100. Whether or not that was something which a trustee complying with the test laid down by Lord Watson, that's in Leroyd and Whiteley, could have done, could reasonably have done.
But I'm struggling here. If you just look at what was actually alleged in this case at page 105, it's all to do with breaches of a duty of care, isn't it? I mean, look at the pleading. Look at the summary of the pleading. It's all to do with not taking proper care, skill or care, isn't it?
Well, a 106.
Yeah. It's all about exercising prudence, care. I thought we agreed earlier on that a trustee who doesn't exercise due skill and care is not the foundation for equitable remedies in knowing receipt or dishonest assistance or anything else against third parties. Is that right?
Well, we're submitting that there are trustee decisions which are so manifestly not in the best interests of the beneficiaries that they are actionable properly as a breach of trust by reference to that test, i.e. there's a line. Okay. It's the same as beyond the range of reasonable disagreement. Once you go beyond...
But that's what I put to you much earlier this morning. Isn't that because, and again I come back to my corporate, I reach for my safety blanket of corporate law. If a director acts in what he genuinely believes to be the best interest of the company, but does so carelessly, that's not a breach of fiduciary duty that would give rise to the sort of third-party remedies that we were talking about. But there will come a point in time at which his conduct appears to be so careless, so objectively inexplicable, that the court will say, as a matter of fact, I don't believe you when you say you are acting in what you genuinely believe to be the best interest of the company, because you're not that stupid. But it's a factual question, not a legal point, is it?
Well, perhaps I should have assented to that proposition first time round. Certainly the way my Lord explains it now, that would be consistent with the structure of the Companies Act, with Section 178, I think, saying that the reasonable care and skill, it's not actionable as a breach of fiduciary duty in the way in which the other codified duties are. That would align with the way in which my Lord is putting it.
And so, there may come a point in time at which somebody's behaviour is so careless on its face that you actually draw the factual conclusion that they can't genuinely have believed they were acting in the best interest of the company, and therefore it is actually a breach of fiduciary duty, but it's a factual question.
Well, I was probably being too sensitive first time round, not to walk into the findings of fact trap that my learned friend said to me, oh, you're just trying to quibble with the findings of fact that the judge has made. We're saying that on any proper objective assessment of the terms of this transaction, as Mr. Crosby himself introduced them, that they cross the line about what's permissible by a trustee loyally doing their incompetent best.
But the problem you do face is that if the analysis is right, it's a factual finding that you say the judge should have made, because these terms were so bad, looking at objectively, he should have disbelieved, he should have found that no trustee could honestly have believed that he was doing his loyal best for the trust. Therefore, you are criticising the
I would be content with that way of putting it, but that's still appealable. It's not.
I'm not saying it's not appealable. I'm just saying you have to identify that if that's the correct analysis, you have to square up to the fact that you are effectively saying that this judgment was irrational on the facts, on the evidence, and he should have found, he could only rationally have found on the evidence in front of him that Austin Fergus was in fact acting in what he didn't believe to be the best interests of the trust.
Yeah, in fairness, I probably was too cautious originally, keeping too much distance away from the findings of fact trap. If we compare it with Henderson and Foxworth, which is the case upon which my learned friend relies, he says, this is really just, you're trying to disturb findings of fact. We say then we're not trying to disturb findings of fact. It's not about could the witness be believed about the consideration for the apparent transaction at undervalue. That's a completely different case. And in fact, paragraph 67 of Henderson and Foxworth says, absent an error of law, ... So, but there is an error of law if there's just simply been a wholesale misevaluation about the nature and effect of the transaction. And then there is the further add-on, which may well be a flourish, but paragraph 23 of the affidavit is that having decided that somebody else's money would be used to make the acquisition, part of Austin Fergus's thinking was that acquisition would be good, because there would be an opportunity for Austin Fergus to consider deploying further development finance to build out for a share of the proceeds. Destination of those proceeds, source of the further development finance unknown. But the point I was making by reference to the affidavit is that we do see the 1.2 million referenced in the telephone call. And if 22 and 23 are applied properly, then that does represent an element of self-dealing introduced by the defendant on their own evidence, and so that's a breach of the obligation of loyalty on the facets of good faith, not acting for one's own benefit or the benefit of a third party.
But was that a pleaded allegation? Because if it's not a pleaded allegation that was put to the witnesses at trial, I don't see where that gets you on an appeal.
I'll return on the pleading, if I may.
But if it's not within the scope of the case that the judge had to decide, I mean, if you didn't squarely make that argument on the pleading, then you can't really criticise the judge for not making the finding.
No, I understand, and I've already conceded it's not the thrust of ground two per se. Moving to knowledge, unless there's anything I can assist on under grounds 1 and 2. Knowledge is grounds 6 and 7. We seek to go considerably further than the permission order, where Lord Justice Lewison regarded it as arguable that even from the face of the checks that...
Well, you say you seek to go beyond the permission order. That's not a promising start for
No.
submission. Sorry.
There is more material to make it amply arguable that Mr. Crosby had knowledge of the breach of trust. The only aspect alighted upon by the single Lord Justice...
So you're saying it's a good point for reasons in addition to those which Lord Justice Lewison gave.
Yes.
But you're not trying to revisit grounds on which you've been...
Oh no, this is certainly distinct from the failed grounds.
No, that's fine.
The single Lord Justice said it's arguable even from the face of the checks, and even acknowledging the fact that Mr. Crosby said he hadn't noticed this at the time, it was regarded as being arguable that the reasonable person would understand that this was not Austin Fergus's own money, even from the face of the checks. We have already been through the transcript, which gives ample indications of Mr. Crosby, completely contrary to his pleaded defence, having a very good basis for understanding that this was somebody else's money. Ground 6 is put forward as a misapplication of the Baden test for knowledge. And ground 7 is more towards what we've just drifted to on ground 2, which is a failure to evaluate the evidence properly.
So can we, but before we just go there, can we just identify what the breach of which it is said that Mr. Crosby knew or ought to have known, and I use those words loosely for a moment, whatever the state of knowledge is it that it was somebody else's money being applied improperly, or what? What is the breach of duty which he is alleged to have had the requisite degree of knowledge?
He's got the knowledge of the breach of trust under ground 1 and ground 2. So he's got the knowledge that Austin Fergus is deliberately deciding to use somebody's money to allow Mr. Crosby to rescue this project, which he so desperately wants to capture.
Without consent?
Without consent, and knowing that it's the sort of last show in town because nobody else will provide the money. Mr. Crosby clearly appreciates that, and...
But knowing that it's somebody else's money of itself wouldn't amount to a breach of duty, would it? I mean, if you borrow from a trust, you know that the trustee is using, quote, somebody else's money, but it doesn't follow that the trustee is breaching trust in doing so. The mere fact it's somebody else's money doesn't get you home, does it? You have to show a requisite degree of knowledge, not just that it was somebody else's money, but that it was somebody else's money used in a way which must have amounted to a breach of trust.
Yeah, it's somebody else's money. He hasn't told me who they are, and I haven't asked him who they are. I therefore haven't made the beginnings of any inquiries to ascertain whether they consent to his use of their money. And
do you have to?
Yes. When we look at the test, and in fact, I think the judge.
Yeah, it might be, but should we not look at the law first here? Because I think
yes.
This is because just saying it was somebody else's money. At the moment, I can't see that of itself gets you home.
No. It's somebody else's money. I don't know whether they consent. I haven't taken any steps to even begin the inquiry about whether they do consent.
But that assumes that is what is required of somebody in those circumstances. In other words, you have to say that they're on inquiry automatically because it's somebody else's money.
I think we can see the test. We've got Lewin in the first authorities bundle at page 134. It's 42-072, but just so that we make sure we're talking about the same thing. So fivefold Baden classification. Number 1 is actual knowledge. Number 2, willfully shutting your eyes to the obvious. Number 3, recklessly not making inquiries which an honest and reasonable man would make. 4, knowledge of circumstances which would indicate the facts to an honest and reasonable man. 5, knowledge of circumstances which would put an honest and reasonable man on inquiry. 1, 2 and 3 are all the equivalent of actual knowledge. They align with each other. That's common ground, and it was common ground.
Just to cut across you, this is looking at the question of degree of knowledge.
Yes.
I understand we're going to come on to that.
Yes.
And that's interesting in itself. But it's knowledge. I'm trying to get to the logically prior question before we get into this deep water of knowledge of what? What is it you say that the knowledge has to relate to? Is it just, I think you accept it, it's not just that it's somebody else's money, or is it? You know, is it?
No, I actually think we come at it a different way, to my lord. So
Okay.
the first question is the court satisfied that there is a breach of trust, yes or no? If there is a breach of trust,
Well,
as a fact...
you don't get to 6 and 7. If you fail on ground 1 and 2,
you would, yes,
you're done and dusted,
yes.
right?
No, however, if there's a breach of trust, the inquiry then simply shifts to the defendant, to the defendant's mind.
Yes.
And you apply...
Did he have knowledge of the facts which amount to the breach of trust? And I'm just identifying what facts we're talking about here. He has to have the requisite degree of knowledge, actual or turning a blind eye to that which would be obvious, let's say, to the clear categories, to the facts which amount to the breach of trust. The fact that somebody is lending somebody else's money, does that of itself put you on inquiry?
Forgive me.
Or whatever?
No. But it's somebody else's money whom I've made no attempt to speak to and ascertain whether they consent, ascertain whether they are aligned with Austin Fergus, that none of this will be put in writing, that we can just all trust each other's word on the matter.
Yes, but sorry, let me just come back. Suppose I come to you and I say, look, I'm a trustee and I have power to lend money on commercial terms. I know you're in difficulty because you can't get money elsewhere. I'm prepared to lend the trust's money to you, because it's within my power. I am, by the way, a solicitor, let's say. And I will make available these monies to you. The terms are that it's going to be security over everything you've got that isn't nailed down. And I'm going to ask for a 20% rate of interest. I'm going to really nail you to the wall.
Right. So there's no indication of breach of trust in that scenario.
And so do you then, in those circumstances, have to say, but before I can take that money on those extortionate terms, which are obviously very good terms for you, the lender, or the people you represent, I have to know who the people you represent are, and I have to know whether they've consented to this. Because as a solicitor, I might tell you to shove off.
No, that's an objectively regular enough transaction that you would not be put on inquiry.
Right.
It seems to me you need to rely, don't you, on let's keep this quiet, words to that effect, undocumented. You need to rely on other sort of, what you would say, obvious irregularities as being sufficient to put Mr. Crosby at least on inquiry.
Well, Mr. Crosby already knows that this source of money, wherever it's coming from, it's the last-ditch attempt to rescue the opportunity and prevent me from losing it, because it wasn't Austin Fergus's first idea to simply use the trust money. He first tried to avoid that happening on the face of it, because he said, here's a man you go and speak to, he's a specialist broker, he'll get you finance.
But once you accept my lady's proposition, which she put more elegantly than I did, that it's fact sensitive. That the question about whether somebody has to ask the questions that you were saying that should have been asked is fact sensitive. relates to the terms and the circumstances in which the loan is advanced. So don't you again have to say, before you get to the interesting questions of the level of knowledge, you have to identify the circumstances, the facts that you say the judge should have found put Mr. Crosby on inquiry. You can't just say that in every case where somebody is lending somebody else's money, that the borrower has to start making the sort of inquiries that you were postulating. And as soon as we accept that, we've got to then start looking at what the judge said about whether Mr. Crosby was on inquiry.
The touchstone ultimately is unconscionability and how one goes about assessing where unconscionability is. Mr. Crosby, having been put on notice that this was not Austin Fergus's money personally, see the transcript, is obligated to inquire. He doesn't need to know there's a written trust deed behind any of this in the first place, but if it's not Austin Fergus's money, then Austin Fergus is holding it. He doesn't need to know what a trust means. Cases have made that clear. But in fact, Austin Fergus is holding the money on trust, whether there's an express deed behind the money or not, or whether it's just he's got his hands on somebody else's money. Mr. Crosby firstly knows this is being done in the first place in order that I can do what I've said I want to do, which is not lose this opportunity. So he doesn't need to know there's an express deed and I'm not an object of the deed. It's not that as such, but there's a resort suddenly being placed on somebody else's money where everything else has drawn a blank. So that is alarming.
Well,
Then
why is it alarming? It may just be the opportunity in the example I put to you for a trustee with appropriate investment powers to extract a very good deal for the trustee represents, which a commercial lender with different trustee obligations is not prepared to do. So, as my lady put to you, the mere fact that, for example, it was being done to help Mr. Crosby out in circumstances where commercial lenders wouldn't, doesn't of itself put Mr. Crosby on inquiry that there's something wrong, does it?
no, I'm thinking now that, in fact, probably the neatest and most comprehensive way for me to put this is directly by reference to the appellant skeleton, paragraphs 36 to 39. And in fact, we can do this with a degree of annotation in the margin as one goes through. So 36A, I would say, see the affidavit, paragraph 13. At 36C, see the affidavit, paragraph 14.
So the marginal thing was, the first one was affidavit at paragraph
At 13. Nothing as such to annotate for B, but for C, paragraph 14 of the affidavit. For D, loan not being documented, see the transcript, page 4. Why would the illness suddenly scupper this development altogether? See transcript, page 15. For F, see the notes of the cross-examination. I said that it may be necessary to look at those. Could we turn to those now, and then I can do this in one go, and then we don't need to go back to them. That's in the supplemental bundle beginning at page 205. On 206, Why, if this was all above board and you didn't know anything about the sort of untoward nature of the transaction, why did the cancer diagnosis paid to the plans for the joint venture to build out the units and earn this income for your lifetime and your children's lifetime? That's addressed on page 206, beginning at letter D. Why didn't you go to Henry and say, look, this was the deal, there's a lot of money to be made there? Answer at E to F, I didn't need to go to Henry. I didn't go to Henry about anything. Austin was the person that I spoke to and dealt with. G, I wanted Austin to have one less problem in his life. I didn't want him to worry about it. Let's move on. I didn't want to be phoning up every day to talk to him about colours of paint, doors, tarmac, curbs. He's got other things going on in his life. That's tested a bit further on 207. Well, hang on a minute. You were looking at a 4 or 5 million.
So which line are you on?
I'm on B on B. 207, but
sorry.
And we don't have this bit transcribed, but it's picking up on Mr. Crosby having said that the end value of the build out would be up to 5 million once you factor in the 1.2 million development cost. D to E, yes, I would expect it to be in that area. 10 units, you'd easily achieve 300 to 400,000 for each unit. H, at the foot of the page, Peel, the big northwest landowner and developer, they'd valued it at 7 million. It was a golden spot without a doubt. You couldn't put a value on it. 208 at letter E, well, that would have all been a terrific legacy for Austin Fergus then, wouldn't it, if it had been built out?
Sorry, at E, you say?
E to F. On this theme of why did the cancer diagnosis suddenly...
Sorry, where's the evidence? Sorry, between E and F, it's just your question, isn't it?
Yes. But
sorry, I don't get anything from any of that.
No, but we come to it. The judge interjects. Then at the bottom of 208 into 209, it was a question relating to Mr. Crosby's evidence that we would build the site out.
Yeah.
Then at the foot of 209, but you didn't need to be asking him about the colour of the paint for the door. And he says, well, of course you do, because if you're going to go into a development with somebody on a 50-50 or a partnership, you're going to have discussions. You're going to have to discuss everything with them. 210, beginning at B. Why couldn't you have just said to him then, Austin, your health is the #1 concern. Leave the project with me. You can rely upon me to sort it out. And Mr. Crosby said, I wasn't interested in carrying on with a project with somebody that's just been diagnosed with terminal cancer. Is the only reason the illness scuppered it because you knew the deal rested on, to put no finer point on it, a dodgy deal between the two of you? No, that's incorrect. Then there's a question about why did he suddenly take his business away from these accountants and how it came to be, top of page 211, that there was an application to strike the first defendant from the register. One can skip to page 226. This is an illustration of how Mr. Crosby was being tested by what he'd said on the transcribed call. Top of 226, why would it be important for you to say to Austin that your advice was that he should not disclose his illness to other people? Mr. Crosby said, I was aware that Austin had borrowed money out to a few people. I didn't want him to disclose that to the people he'd borrowed money out until he'd got on top of all this stuff.
Just trying to take, is it 226?
Sorry, my lord, yes, 226, beginning questions at the top at A.
Sorry, yeah.
So, Mr. Crosby being tested on the further part of the transcribed call, why was it that your advice was he should not disclose his illness? And he said because he knew that not only had he received money but so would other people, and he didn't want those people to take advantage. The judge at E said, yes, well, what do you mean? What exactly did he need to get on top of? And Mr. Crosby said, well, he had a lot of loans, Mr. Cawson, my lord, sorry, that he had out with people that I was aware of. And I'm thinking to myself, if these people are aware you're sick, they'll disappear. I was right, half the businesses failed straight after he died. And then at G. So your belief was that other people had received money on the basis of no documentation and it being just on principle. And Mr. Crosby effectively said, yes, said I asked him, I hope you're not like this with everybody. This is considerable confirmation of Mr. Crosby having a distinct appreciation that this is highly irregular and that one needs to tread very carefully in order to protect the in-principle arrangement. Finally, for completeness, just given that we're looking...
Sorry, wait a minute. This is a discussion after the cancer diagnosis about the effect that disclosure of Austin Fergus's imminent demise would have on recovering money from people.
Yes, because that he knew that not only have I received money on completely undocumented terms, but so have other people. They will take the opportunity to misuse that, take advantage of the situation.
Yeah, they would deny the existence of the loan, for example, and the like. Yeah.
So it's a measure of the appreciation of the extremely, well, from the beneficiaries of the trust point of view, the extremely delicate and, well, frankly, flimsy to the point of being...
it's an appreciation of the problems that somebody would face in relation to other people getting money back. Yeah,
the people whose money it was.
Whatever level of knowledge that needs to be established, you have to establish it as at the date of receipt.
Yes.
So one of the issues you would have to deal with is that this is a conversation, this is a discussion of something happening much later when the state of knowledge may have changed.
That is true, but that's been taken into account. The written skeleton argument concentrates on things that were apparent at the beginning. Just before we leave the transcript for the cross-examination, for completeness, page 266, because just to pick it up, because this is mentioned in the skeleton. So the judge, after cross-examination and re-examination had finished, asked Mr. Crosby a direct question, and it goes to my lady's point. Well, to some degree it does. When do you think you first heard of SPH?
Which page?
266 at the very top. Because, of course, we'd seen in the transcript that Mr. Crosby volunteered SPH, even though Mr. Shovlin hadn't identified it. So that appeared to stay in the judge's mind, and so that's one of the early questions that the judge asked. Mr. Crosby's answer was curious. As we've said in the skeleton, because he said the first time I was aware SPH had anything to do with me was early in the February. That's clearly not an actual answer to the judge's question. That's just a small forensic point, but that was letter G of paragraph 36 of the skeleton. Paragraph 37 of the skeleton, we say unconscionability, which is the touchstone, is manifest because an honest and reasonable man of business would have asked himself all those questions. But Mr. Crosby deliberately refrained from asking them.
Well, okay, let's just start looking at the questions. Why is it suspicious that Austin Fergus would have referred Mr. Crosby first to a specialist mortgage broker rather than lend himself? I mean, why is that suspicious? No,
it's having already referred me to a broker, okay. and we get nowhere.
All right, so he puts you on. He puts Mr. Crosby onto a specialist mortgage broker and Mr. Crosby's turned down, is it of itself suspicious that Mr. Fergus then says, well, okay, you've been turned down, I actually have a source of funds, whether myself or somebody else, that can lend to you? Of itself, why is that suspicious?
Well, we're testing this against the defence. The defence is, I have no reason to believe that this isn't Austin Fergus's money personally. And we say that's nonsensical. Because, of course, if it were to be Austin Fergus's money personally, why divert to go to a specialist mortgage broker first? Why don't you just make the money available?
Well, he just might not have wanted to. He might have had other things he wanted to do.
Well, he may have done, but the honest and reasonable man asking the obvious questions, that's one of the questions that one starts with. It's not the only question, but we say an honest and reasonable man would think, well, this is a bit curious because I've told him the RBS won't lend to me. And his immediate thought is, well, I've got a potential solution to that. The solution doesn't work out. Suddenly, he said, I can lend you my money. So,
see, I don't know. Of itself, I don't see that as naturally suspicious. You don't. Why?
I agree in itself. It's the beginning. It's the beginning of the inquiry.
Okay. See, I suspect we're going to drill down to, again, as my lady put to you, it's actually probably going to be the terms upon which the loan was advanced, which are the cornerstone of your proposition that Mr. Crosby should have been on an inquiry.
Yeah, I'm a bad risk. The market tested at top level and sub level regard me as a bad risk, so I can't get the money commercially. I'm now getting some money, which is the equivalent of what I'd wanted from RBS. I'm not having to give any security in the way in which unquestionably I would. It's to a degree hush-hush, and whoever's money it is, he's getting next to nothing for it. Not only are they not secured, but they're getting no appreciable rate of return at all.
But the deal with Austin Fergus is, even leaving aside all the oddities, is different in kind from the deal which might have been done with a commercial lender, because the commercial lender would simply lend the money and its return would be the interest and it would take security, whereas the deal with Austin Fergus is more in the nature of some kind of joint venture by which Austin Fergus or Austin Fergus on behalf of the trust will share in some way in the profit. And that's a fundamentally different deal from what the commercial lender might.
Certainly, but completely on faith only.
I take that point, yes.
And without any inquiry, well, hang on a minute. Who are these people? Are they the sort of McKenna people? Or no, they're not McKenna people, don't worry. Well, had I better check for myself that they agree with you, that it doesn't need to be put in writing? Should I find out now who they are rather than wondering who they are? And so on and so forth. And he effectively closes his ears, because it actually comes to, I mean, I know we're fast running out of time, but it comes to why there should be a liability on a knowing recipient to account for profits, because this is all his moral justification for getting the money in the first place. I know I can back myself. I know money where I see it. I know the value of the site. If it's left to me, I will make money, and I'll have a surplus that when called upon, I can use to discharge what I think my obligation is. I'll set my own standard of behaviour.
Before we get ahead of ourselves and start looking at accounted profits and otherwise, you have to attack, don't you, under these grounds? You have to attack the judge's findings about the state of knowledge or the obligation to make further inquiries at the point of receipt of the money.
Yes, so if we now look at Lewin.
So yeah, I mean, can we focus? So it's the state of knowledge of, I go back to my question, is it the state of knowledge of facts which amount to a breach of trust which need to be known about to the requisite degree of knowledge? And if so, what are those?
Well, is it not just knowledge which makes it unconscionable not to get to the bottom of the transaction and to flush out the answers to these questions?
Yeah,
It's unconscionable. No, the test is knowledge to make it unconscionable to retain, isn't it? Or it's not gloss on the
Yes, but
test.
If you deliberately refrain from asking questions which are designed to flush out the answer to the question, is there a breach of trust by you, Austin, or not?
Yeah.
If you decline to ask those questions, you have acted unconscionably.
Okay, but the judge was dealing with a factual scenario which included findings that Mr. Crosby had had trust for a long time in Mr. Fergus. I mean, those factual, we're not, the judge isn't asking himself whether those questions should be asked in some sort of hypothetical scenario. He's dealing with a situation where Mr. Crosby knew Mr. Fergus well and had trusted him in business affairs. So you, as my lord says, you're having to attack the factual findings and made in that context.
Yes, I mean, he doesn't know who's behind Austin Fergus
No.
because he's interested in what type of person it is and whether he can trust Austin Fergus saying to him, you don't need to worry. He knows he's getting into bed with somebody, but he doesn't know they're disguised, and he's got no interest in lifting the disguise. But he wants to know that the bedfellow is not a certain type of person and asks that question. But that's the only question, and then deliberately has got no interest in going further and saying, well, do they know... What about all these aspects at paragraph 37 of the skeleton? Are they definitely prepared to lend without security? Do they know? I know you know, Austin, but do they know that the RBS have said no and that the broker you sent me to has said no? Do they know that? Because that might be highly material to their decision as to whether they're prepared to lend or not. And of course, if they're not prepared to lend, then you using their money knowing that they're not prepared to lend, that is a breach of trust. So it is a knowledge. These questions are all directed to the knowledge of the breach of trust.
So he has to know, he has to have sufficient knowledge of matters that would put him on inquiry, if he's an honest and reasonable man, as to whether there's a breach of trust or not. I mean, that's the question, isn't it?
Yes.
If he thinks that Austin Fergus is lending the money personally, it's not a breach. There is no question of breach of trust, is there? Because Austin Fergus can be as nice and as stupid as he wishes with his money, and that's an end of it.
Exactly. He's a quasi-friend. If it genuinely is his money, as per my defence, I've got no questions to ask.
So the first thing that he has to have either known or turned a blind eye to is that it isn't Austin Fergus's own money. That of itself, I think we established, is not of itself enough, because it could perfectly well be the case that Austin Fergus would be entitled to lend him somebody else's money in compliance with his fiduciary obligations. What I think you've got to point to are the facts which say that any honest and reasonable person would realise that there's a possibility or question about whether Austin Fergus is actually lending somebody else's money on an improper basis.
Do they know, Austin, what you know?
Well, it's my lady's point to you, I think, isn't it? It doesn't come down to saying, is this a situation in which an honest and reasonable man in Mr. Crosby's position would have said to himself, wait a minute, this isn't Austin's money, and I'm getting too good a deal this is too good to be true.
Indeed.
But you have to be quite granular, don't you, about the particular facts that Mr. Crosby knew in the particular circumstances of his relationship with Austin Fergus, and you have to attack the judge's analysis of those facts. I do think you've got to be, on this, really quite granular about which specific facts he either knew or you say turned a blind eye to. Before we get on to questions about the exact degree of knowledge required, let's just take it at its highest. You've got to identify the facts which you say the judge didn't take proper account of. And at the moment I'm struggling to, I mean, you sort of listed some of them, but I think you need to be really much more granular and actually attack the judge's dealing with these points.
Well, it's 37. Paragraphs 36, 37, and 38 of the skeleton. That's the appellant's best effort of the matters which the judge failed to evaluate properly through the prism of the conscionability of Mr. Crosby's conduct.
I mean, can we look at the judges, where the judge dealt with this area?
We start at paragraph 207.
Well, I see it's 1 o'clock or thereabouts. Shall we do this at 2 o'clock?
Yes. And then, how am I doing for time in terms of time management?
Yes. Well, how are you?
Well,
you're on course to finish today, I take it?
oh yes, yes.
Well, we've got 2 days for the
Well,
appeal,
in fact, that was the question. It wasn't actually clear whether we were. The website suggested 6 hours, but the early indications were potentially 2 days.
Right.
Perhaps we should have established that at the beginning. But
Yes. Well, our understanding is that it's down for 2 days. So if we need the full 2 days, they are available. If we can do it quicker, then so much the better for everybody. But I think that means that you need to complete your submissions by the end of today.
yes,
We'll rise at 4:15 as usual, and Ms. Truff will have most of tomorrow, leaving you some time for a reply. If we need to.
Well, that's a very helpful indication. We're not under the pressure of time that I thought we might have been.
All right.
If it were a 6 hour all in.
Perhaps for our part, we'll try not to interrupt you so much, so to make sure that you do complete your submissions on time. All right, 2 o'clock. Thank you.
All right.